everybody. Nice to
Morning.
see you at the Ask the Expert session. I'm delighted to have Erika Morales Perez. I love that name. That is fantastic.
Thank you.
From Virtual In-House Lawyer, talking to us today about any legal issues that you may have. So this is contractual type questions about supply chain with customers and suppliers. So this is an area where, as we were saying before, Erika, is somewhat unsexy. However, it is so important. It really underpins your businesses. So it's a good opportunity to ask any questions that you may have. I know Erika's got some great advice for us and things to look at and things to think about. So with no further ado, I'll hand it over to Erika.
Thank you very much, Chris. Good morning, everybody. I know Anik, obviously. I don't know the Ali Bones, as Chris introduced you, so good morning and nice to meet you. Nice to meet you, Nick, as well. So as Chris said, my name is Erika Morales Perez. I'm virtual in-house solicitor and I offer a virtual legal service, essentially, very untraditional, but supporting my clients in an untraditional way. So very commercial. I used to be in business myself. I spent 10 years in business. So I understand the contractual relationship that you have with clients. And actually, I've really been in the thick of it as well. So I don't come to law with just a legal perspective. I come from a real business perspective on how the law impacts the business. And I try to, throughout everything I do, I try to intertwine the two so it's commercially viable and so that we can actually meet our business objectives. So I'd like to think I don't speak like a traditional lawyer. I'm hoping that everything I say will be understandable, but please do interrupt me, ask questions. The whole idea is that this is really your session. So I have prepared some notes, so forgive me if I'm looking down to refer to them, but there's a couple of key areas that I wanted to make sure I covered today. And we're essentially going to be looking at, as Chris said, the commercial contracts and how your contracts with your customers and your suppliers might be affected by the unprecedented times that we find ourselves in with COVID-19 and what that means to businesses. So I will kick off and I'm just, as I say, going to cover a few things. Now, you probably saw in the bullet points that were circulated what we would like to cover is essentially four main areas, but please stop me if it's not useful and ask specific questions. But what is force majeure? We'll cover. Is COVID-19 considered a force majeure event? How can you rely on this clause? And what to do if you don't have a force majeure clause in your contracts. Now, one of the things I always say to clients, and whenever I'm networking or speaking to people about why you should have a lawyer, is that on average, statistics show that small businesses spend around £6,000 a year in legal fees on issues that could have been easily prevented by way of a simple contract. And that could be a one-page contract. It doesn't have to be extensive. So I always recommend we have contracts, but I also understand that we don't always have written contracts. Now, in English law, and this is a bit of a boring bit, so forgive me, but I will just cover it quickly. In English law, you do not have to have a written contract for a contract to be actually formed as far as the law sees it. So you can verbally contract and agree your contractual terms, never sign anything, and it could still be something that would stand up in a court of law. So at this time, in these unprecedented circumstances, we're probably all thinking very long and hard about whether or not we can honour those commitments. Now, the difficulty if you don't have a written contract is that there isn't any statutory provision. So that means that in law itself, there is no force majeure provision. So you may have all heard of implied contract terms, whereby, for example, you don't have it agreed in your contract with your client or your supplier, but a term can still be implied by law because there are statutory provisions, and therefore you could seek to rely on that. The same cannot be said, sadly, for force majeure provisions. So if you do have a properly drafted contract in place with your customer or your supplier, then it's highly likely that you have a force majeure clause within it, because that's what we would call a boilerplate clause. So I would never draft a contract without a force majeure clause included in it. And what force majeure does, is it's a very simple sentence of a clause that's intended to excuse one or both or all parties from performing some or all of their obligations under a contract due to an event that is outside of their reasonable control. So the next question would be, in law, is COVID-19 a force majeure event? So does COVID-19 fall within the category of it being outside of your reasonable control? And what do you think? I think a lot of you are muted, but I can see some nodding heads and some thumbs up. Yeah, absolutely. From a legal perspective, and my colleagues and I have done a lot of research and we've considered this extensively, as you can imagine, over the last couple of weeks. And we're absolutely certain that the current coronavirus pandemic falls in the category of outside of your reasonable control. Excuse me. Now, sometimes there are specific provisions within your force majeure clause, and that could be political force majeure, which deals with risks related to changes in political or legal environments. Excuse me, losing my voice now. It's a great time for the voice to disappear. And then you can also have a non-political force majeure. So you may have heard of words in contracts such as acts of God. And they are often uninsurable events, but events that can fall within the category of a force majeure event. But the different categories often provide different remedies, and that might mean that a remedy is an extension of time to fix something, or it might mean that in order to fix it there is an additional cost, or there is an extension of time for completion, or that you could terminate the contract if you can't fulfill. But it really depends on what the force majeure clause says. So given the impact of this spread of COVID-19 and the effect it's having globally on businesses, it's possible that that everybody at this point is looking to their force majeure clauses to see how they can rely on those. So the first step is to check that you have the clause in your contract, and then check the specific wording to see what action you need to take to rely on that clause. Now, if you have that clause in your contract and you are contracting with your customers based on your own standard terms, then this should be a very straightforward exercise. However, if you contract, as many of my clients do, on terms of their customers or clients, then it may not be as straightforward, because it may be that you have to check various and numerous, it could be, contracts for the force majeure provisions in each of those contracts. And if they are numerous, one client of mine in particular, we look at approximately 5 contracts a day for them and their clients, so they would have hundreds of contracts to review. My recommendation is that you focused first on your key customers. Now, within force majeure clauses, typically you will be required to notify your customers or your clients that you have been impacted by a force majeure event and what that event is. Now, I realise that one might have to be living under a rock in a cave to not know what's going on at the moment. And even if that were the case, it would have to be a pretty robust rock or cave in order to not know what's going on, as it's had such a global impact. But it's really important that you communicate with your customers and you tell them what is going on and what steps you are taking in order to mitigate, and I'll come on to mitigation in a second, the force majeure event. But essentially, you will need to notify your clients. And to do this, you can do it via email, but we always recommend as lawyers, because we like paper as well, that you follow that up in a letter as well. Now, thankfully, Royal Mail is still functioning at the moment, so we're still able to do that. But essentially, the key here is really understanding what your clause says, what your obligations under your force majeure clause says, and making sure that you comply with those terms. So, for example, if it says that you can notify by email only, then that's absolutely fine. If it says that you must notify in writing and isn't explicit about it being okay to do so in email, then by not giving a written notification by way of letter may put you in breach of your contract. And I know it sounds like a silly thing, but it's a really key element. So make sure you do that and you notify your client. So what happens then once you've notified your client? So it may be that it's a third party in your supply chain that hasn't been able to supply goods to you, or in many cases, for most of us, services. So I don't necessarily supply goods, as you would imagine, but I do use other lawyers to fulfill some of the areas of law that I don't cover, such as commercial property and employment, litigation, and things like that. So if somebody can't supply to me, but I am still supplying the services that I do to my clients, then again, you need to go back to the contract and check the wording in your force majeure clause. Some force majeure clauses expressly exclude subcontractor or third-party supplier default. So, if that is the case, it may be difficult for you to invoke your force majeure clause. However, you still have the possibility to argue that you have been, albeit indirectly, affected by the pandemic. Now, again, in the situation that we find ourselves in today, it's pretty easy to argue that you have been affected in some way or another by the pandemic. In which case you still have the ability to invoke your force majeure clause. You should still take steps to find an alternative supplier or source of your services or goods in order to minimise the impact of the force majeure event on your business. Now, from that comes a duty to mitigate as well. So you have a contractual right to be able to invoke your force majeure clause, but you also have a duty to mitigate the impact. And that means minimizing the impact on your customers or indeed your suppliers. Now, the upside of this situation is because it has such a global spread and it has impacted businesses globally, it's relatively unlikely, and what we're seeing across the board, myself and my colleagues, is that people are not really disputing the invocation of force majeure clauses at this point, because everybody's suffering in the same areas. Everybody's suffering and struggling to fulfill, whether it's goods or services. Not everybody's set up at home. You might have issues with some of your employees or the freelancers you use supplying their services because they don't have the technology at home. They're having to work different hours. They're supplying and potentially not on time. So there's all sorts of different elements that could be impacted by this. And because everybody is suffering in all areas across the board, it's difficult. It's an easier position to be in order to invoke your force majeure clause. I don't know about you guys, but I have some small children and a puppy running around, so quite often delivering my services in a professional way is quite difficult because they'll run into the office and as kids do, and puppies in fact, because he's well, he can be as inconvenient as the children at times. So we're all struggling in different ways. So the point is that everybody is probably going to take a pretty pragmatic and sensible approach to this at this time. Now, you may have also heard that tenants, commercial tenants and residential tenants at this point can't be evicted from their properties. And that's because everybody across the board is being cut some slack in terms of any possible courses of action that might usually be sought to be relied upon. And force majeure is no different. So we've spoken about the force majeure clause, and now we're going to talk about how to mitigate and how to minimize the impact of the pandemic on your business and your customers. And the reason that's important, as I said before, you have a duty, if you're going to seek to rely on force majeure, that you minimize the impact. And this should be you looking at the steps you need to implement in order to continue your business. Now, in most cases, this will involve initiating your business continuity plan, and most of the clients that I'm working with have taken steps to do that. So one particular client is a city listed business, and they've had to put all of their set up all of their employees to work from home, but they are basically operational. Now, interestingly, you might expect very large city listed PLCs to have excellent business continuity plans. And let me tell you, businesses big and small do not have them. So it's very much been a case of scrabbling around to see what we have to do to make sure employees can be at home, working effectively and efficiently. And as an employer, if you are one, you might be wanting to look at how you can support them to ensure that they feel supported in those environments. I know Chris has already arranged some webinars and some Q&As with HR specialists and employment lawyers, and I'm sure they've spoken to you about furloughing and those types of options. But essentially, if you do let your workers work from home, that's fantastic where it's possible. If not, my sister, for example, runs a sales team in information technology distribution. It's very difficult for them to work at their full potential whilst they're working from home. So what they've done is they've actually split their sales teams so that half of the team go in one week and then the other half of the team goes in for the other week. And what they've done, they've agreed that they can therefore cut the wage bill by half, but it also means that they're separating the teams physically enough to avoid any cross-contamination, because it's simply not possible for them to work from home at all times. You might also want to consider, as part of your minimisation, your mitigation, how you would be available to maintain the level of service or the delivery of your goods if a key member of your team were to become ill, and how you would cope with that if somebody had to self-isolate. We've all seen that even Boris Johnson is not immune to COVID-19. So his team has had to step up around him. The cabinet have all had to step up and practice what they preach, essentially, and continue running the country whilst key members of the team are in self-isolation. And I myself have been in self-isolation for the last 2 weeks because my youngest son developed symptoms. So it's been about, my husband and I have both had to juggle working from home, making sure that we've got the provisions in place, our key team members doing what they need to do so that we can still deliver the services. And you can imagine that this is quite a key time for my clients in terms of looking at force majeure and how they mitigate their losses and continue to provide goods and services to their clients as well. But again, the key here really is communicating with your customers and any third parties that you use in your supply chain and trying to prioritise orders where applicable and adjust other timescales for delivery where that's possible. If you don't take the right steps with regards to the mitigation, then it may be that you can't rely on your force majeure clause, but communication is absolutely key. So another key area of force majeure, you may have already experienced that customers claim that they can't pay due to force majeure. Has anybody experienced that over the past couple of weeks? We all know, thank goodness, that we all know cash is king when we're running a small business, and in fact in any size business cash is king. For my very large business that I've been working with over the last few months, they've revised their forecasts and they have established that they can get through to essentially the end of September as they are, assuming that they have a massive drop in income. So they're looking at mitigation in that regard, how they can either furlough employees, look at reducing salaries. They're actually a very honourable organisation. I've been very impressed to see how they've behaved in regards to dropping salaries, and they've started at the very top of senior management and the leadership teams, and they're dropping salaries from the top down. So with the end result being that those on the lowest salaries within the organisation don't have any salary drop at all over this period, which they're expecting to be around a 6-month period. So again,
I heard of one organisation that just went in there and put the whole organisation on a 20 grand salary.
Okay.
That was it. That was just from top down.
Yeah. And that's certainly another alternative. I work with a bakery business that supplies the hospitality industry. So the floor literally fell out of his business within 24 hours. And that was 2 weeks ago. And he'd also just bought another failing bakery who was a supplier to him. So he had bought that particular bakery as well out of administration, combined it with his own. And part of the benefit of buying the failing organisation was that it had some lovely clients like the Goring Hotel in Mayfair, and then, of course, the bottom fell out of the industry overnight. So he had a chat with all of his employees. Many of them have been with him from the start. They're all very loyal. And they all agreed that they would essentially take a 3-month sabbatical. Because the alternative was they would all lose their jobs and they would all be made redundant. Now, of course, I realise that's not always an option for some people. For my husband's business, he agreed about 2-3 weeks ago, he agreed with his employees that he would drop all of their wages by 20% initially. And then he said that if they hit certain sales targets by a certain point, then they would get that 20% back, assuming that we're in a better position at that time. But the bottom line is they can earn that back, that drop. Now, of course, that's not always possible. And for some businesses, 20% drop in salary is not enough to survive. So it has to be relative to your organisation. Thankfully, at this point, the banks have not been impacted by this pandemic, so we can still make payments electronically. And therefore, it's unlikely that a customer can claim at this point that they're unable to physically make the payment because of the force majeure event. But it may be that they're suffering with cash flow issues, and obviously that's something that we would have to take into account. In normal situations, businesses would be looking at debt collection options for those payments and to recover them, but it probably wouldn't be, it would probably be frowned upon, let's say, in such a global crisis to be seeking to recover debts in that way. So what I would advise, and what I'm advising my clients, is that during these unprecedented times, perhaps you might consider working with your customers to agree an adjustment to their payment terms. So for my bakery client, on his commercial lease, we've arranged a 3-month payment holiday for his rent. Because at £10,000 a month, when he's got no income at all, that's just not possible. The running costs alone are potentially crippling to his business, let alone having to pay for the lease as well. So think about payment holidays, think about longer credit terms. It might be that clients have got 30-day net terms with you, extend them to 60 or 90, for example. It might be a consideration. It might be that you continue to supply services to them, but what you agree with them is that they pay your current invoices for any work that you do between now and the future. But old invoices that are unpaid as at today, they pay you 20% of those invoices as well. So you're still continuing to supply the services to them, but you're also receiving some of the old debt that you're owed, or something like that. There are lots of ways to skin a cat. It's about thinking a little bit creatively. But the key is, again, and I repeat myself constantly in so many areas of the law, but essentially, whatever the situation, communication is absolutely king. Communicating and taking a really pragmatic approach will be critical to enabling as many businesses as possible to survive this crisis. And again, I mentioned earlier, you know, the upside is that we're all in this together. One of the things I keep telling myself, as much as I keep telling my clients, is that my clients are not coming to me because they're going elsewhere. They're just not going anywhere. And I had a chat with a lovely lady who's a branding photographer earlier this week, and we had that same conversation. She said she was feeling quite uneasy. You know, what are her clients doing? Everybody had cancelled their contracts with her. She had a great pipeline of work, and they've not only said put it on hold, they've gone, that's it. That's not a spend that we can justify right now. I want to cancel. And that's fine. As I said to her, the likelihood is they will come back. They're not shopping elsewhere. They're just not shopping. And I think we all have to take a little bit of comfort in that. So we've spoken about force majeure and what it is. We've spoken about, well, we've all agreed that COVID-19 is absolutely a force majeure event. We've spoken about the procedure and how you can actually seek to rely on that clause. But what do you do if there is no force majeure clause in your contract? I already mentioned that in many cases we can rely on statutory provisions to enforce certain bits of law that we don't necessarily have either written down or verbally agreed in our contracts. And that's not the case with force majeure. However, there may be a backstop, and that backstop may be the principle, the doctrine of frustration of contract, which is not an easy doctrine to rely on. It would be a litigation matter. Again, I think that in these situations, it's probably reasonably unlikely in the businesses in which we all practice that any other business would be saying, I'm sorry, you don't have force majeure, I'm not going to let you rely on that. This is a completely commercial comment, not a legal comment. But I'm pretty certain that picking up the phone and having a sensible conversation with a peer, your clients or suppliers, this could be sorted out without having to have a bust up over a force majeure provision. But it's always good to have this in your back pocket if you do need it. So frustration and force majeure are very closely related, but they are also very distinct and separate. So unlike a repudiatory breach of contract, so a contractual term that I don't fulfill and therefore I'm in what is a repudiatory breach of contract, it requires, then that requires an injured party to elect to terminate. The frustration will automatically discharge both parties or all parties from the performance of their future obligations under a contract. A contract will usually be discharged by frustration where, after the contract's formed, an event occurs that renders that performance, so means you can't deliver, so it renders the performance either impossible, illegal, or radically different from what was originally contemplated by the parties of the contract when that contract was formed. So it's not a doctrine that is likely invoked, and it doesn't apply where the parties have made an express provision in the contract for if that risk occurs, so by way of force majeure. I don't really want to go into frustration any more than that because it's, as I say, quite a complex area of law and it would lead to litigation. So, but I did just want to touch on it so that you know there is an alternative. But as I say, there are, other than frustration, there is no statutory provision for force majeure. So if it's not in your contract, it's going to be really difficult to rely on anything like it. So the conclusion then is that if you wish to rely on your force majeure clause and you provide goods or services, you must ensure that the clause is in your contract and you must ensure that it is a genuine event outside of your control and that it has genuinely affected your business. And that's absolutely the case if you sell to consumers as well. There's no doubt, we've all agreed, and all of my legal peers also agree with me, that the current pandemic and its impact on the UK is definitely an event outside of the control of any business. But you must be able to genuinely show how it's impacted your business in order to rely on it. Now, I also have a client that provides leisure facilities to consumers. And one of the things that they've been struggling with is they take bookings way in advance. In fact, it's very difficult to get a booking with them because they're so popular. So from a cash flow perspective, that's fantastic because they take a deposit and then their cancellation policy is such that if you have, for example, a group booking, you can't cancel with less than 30 days notice to them without losing your deposit. So we've had a number of issues crop up with this particular client over the past couple of weeks. And the first was, do my normal cancellation policy terms apply? And the answer is, they don't not apply. But this particular client doesn't want to be seen to be taking deposits in a crisis. A lot of the bookings that they take are from families. Essentially, it's a very kiddie orientated leisure facility, and many of the bookings that they take are for birthday parties. So they want to be seen to be doing the right thing, but of course they also need and absolutely must protect their own interests of their business, because as we always come back to, cash is king. So having to return all of these deposits has a massive impact on their cash flow. So I had a long chat with the client yesterday, and the question was, what do I do? Do I have to, should I refund these deposits? Should I not? You may have all heard now that airlines are no longer offering refunds. What they're saying is take a voucher. I'm supposed to be in Spain on the 12th of May with my friend. I'm absolutely gutted that it's not going to happen, because it was a child-free holiday for 4 days with my pal. It clearly wasn't meant to be. But EasyJet have sent us an email and said, look, we're not going to offer you a refund right now, but we're going to give you 12 months to reschedule your flights. So you can pick any flights. There are no restrictions. You can go anywhere. Here's the voucher. And they haven't really given us an alternative. Now, with my consumer rights, if I wanted to seek to rely on those, and I called them up and I said, you know what, you haven't been able to deliver on your contract, your end of the bargain, you should give me my money back, then the likelihood is that they would give me my money back. But what I've done, and as I've said to my leisure client, is offer everybody a voucher to reschedule their parties and to reschedule their bookings, because probably 50% of the individuals who already have paid a deposit and booked will elect to take the voucher, and 50% will ask for their cash back. If you offer cash back to 100% of your bookings, guess what? 100% of your bookings are going to want their cash back. So try to think about things pragmatically. Try not to offer too much upfront. Offer an alternative. For me, it's quite convenient having a voucher for my holiday, because if I get my money back, my husband might say, oh, well, you've got your money back, never mind, don't go on your girly holiday. Whereas if I've got a voucher, I've got to spend it. So, you know, sometimes these things work for everybody. But just think about what is most convenient for you and your business, and offer that to your customers. Ring them all individually if you have to. Send out a blanket email. With my leisure client, we're sending out blanket emails. With my PLC client, they're paying the most critical invoices, reducing payments on the less critical invoices. They're trying to be both honourable and pragmatic from every perspective. So just think about it clearly. But the conclusion really is that none of us knows what will happen over the coming weeks and months. We think from a legal perspective, the hard bit will be for the next kind of 3 months, which I think is the government guidance essentially. But look at your contracts in detail, try and understand what it means for your business, and if in doubt, seek professional advice in that regard. Any questions?
Hi, Erika. David, I'm here with Nick West.
Hi, David.
Hi.
I can.
Oh, hi.
Hello.
Sorry, I've got a young. See what I mean about these things happening.
You stole the shoe there.
Sorry, apologies. Carry on.
No, that's okay. With regards to utility companies, so for instance, you know, water, gas, electricity, can we write to them and say, look, we want to suspend payment, or we want to reduce payments? Is that a normal thing to do?
Yes, absolutely. So I would urge everybody to only be suspending payments where it's absolutely necessary. And in fact, another client of mine has, he had some old debt actually from, this was a business that I worked with him to recover. So he was on the brink of bankruptcy and I worked with an insolvency practitioner to bring the business back to life. And as a result, he had quite a lot of old debts, and one of them was with RBS, and we wrote to them 2 weeks ago to say, look, you know, he's only paying 50 quid a month to repay the debt, which is around £4,500, which he's been doing for a couple of years now. But what we did is we wrote to them and said that in continuing to pay that £50 a month, it would mean that he couldn't pay other more essential creditors like gas and electricity in his particular case, and a mortgage. And obviously that mortgage paid to put a roof over his family's head and that type of thing. And in actual fact, that worked very well for him, because they wrote back and said, look, you know, totally understand, we're going to close your account and you don't have to pay another penny ever. So he had a little, what we would call a Brucey bonus in that regard. But the answer here, David, is yes, absolutely. If you genuinely are going to struggle to meet other more important and more essential payments to other creditors, then please do write to your creditors and ask them for a deferral in payment or a reduction in payment or something like that. So it's perfectly reasonable to do so, yes.
Okay, and the other last two are with regards to mobile phone companies. So for instance, obviously I'm not using my mobile phone because I'm not outside. Can they suspend the contract, or do I try and terminate it under the force majeure?
Well, I would say it's difficult for me to advise on that without seeing the terms of the contract. Yeah. If it is force majeure, the likelihood is that they would be able to invoke that force majeure if they were unable to provide you with the service. If you can't comply with the terms because they are a supplier to you, then you would have to contact them and say, I can't fulfill the terms of my contract. That's going to put me in repudiatory breach because I can't pay you. So why don't we agree that you'll just terminate the contract with no further effect on me?
Right, and finally, car insurance. If you're not using your car, but you have it insured, is there any way to save money with those guys?
Well, again, it very much depends on what the exact terms of the contract are. There is a legal obligation, of course, to have insurance on a car, as far as I'm aware, it doesn't have to be used to need to be insured unless it's sworn as being off the road. And forgive me, this is not my area of expertise, so I would caveat this with that. But again, if you're making direct debit payments and you're struggling to meet those payments and you're genuinely not using your car, then perhaps it's worthwhile asking for a payment holiday in that regard. I know a number of banks are offering payment holidays on mortgages. So I think the answer is that anything is possible at this point in time. Although again, I would say that if you are going to ask for payment holidays, I would always advise that it's because it's a genuine need.
Yes, I have a question. You were mentioning your holiday and asking for a voucher. What will happen if the airline goes bust?
Well, that's the difficulty. So if the airline goes bust, then I may be able to rely on the ABTA, I believe, or the ATOL protection. And I can't remember off the top of my head, but one covers package holidays and one covers flights.
Yeah, ATOL covers flights, yeah.
Yeah, so, or I could seek to rely on my holiday insurance. I mean, for this particular flight, I think the flight was 90 quid, Anik. So on this one, I have to say, and I'm in a fortunate position that I was willing to take the risk on the 90 quid. I have to say, if it was a 900 quid flight, I'd probably be asking for my money back just in case.
Yeah.
I was just thinking, what happens what position are you in as a business if your suppliers haven't got in touch with you at all? You're saying that it's the right thing to do for us as businesses to contact our customers, but what happens if suppliers to our businesses haven't got in contact with us? What sort of position are we in then?
Well, that really depends on whether or not they've ceased to provide the service that they provide to you. So if they're not getting in touch with you and they can't provide you with the service, then you would be well within your right to contact them and say, hey, look, what's going on? What do we need to do here to sort this out? Can you provide the service or can't you? And how are you going to mitigate?
Yes, I have another question, Erika. You mentioned email versus letters. I thought an email was legally binding, is it not?
Yes, it is, absolutely, but not if your contract says it has to be in writing, and it doesn't say that notice can be served by email. So it's a very important distinction. So I personally, when I draft contracts, I always remove the reference to being able to serve notice by facsimile. A lot of the businesses that I work with, these millennials, millennials wouldn't even know what a fax is. So, and personally, I don't have one in my office anymore either. So yes, email and digital signatures are also binding. And actually, I've just teamed up with another law firm because insolvency practitioners are having a bit of a tough time at the moment because most of their statutory declarations have to be physically signed before a practicing solicitor, physically in front of, and of course that can't take place at the moment. So we've developed a system whereby we can actually film so we record the signing of the contracts on this type of setup through a very sophisticated piece of software, and it's actually permissible in court. So email is allowable, digital signatures are allowable, and in some cases videos of signatures are also allowable. But please ensure it says so in a contract if that is a
question, Erika. Yeah. We have never really had any written contracts with any supplier or client ever in over 25 years. So I'm wondering what you were talking about verbal contracts. Do you think is that something that you would actually sit face to face with somebody and agree verbally, or do you think we may have entered into a verbal agreement with clients unknowingly, and should we actually consider?
Okay. Well, I would absolutely advise that you do have written contracts. I'm, as you would imagine, I am a huge advocate of if you write it down, it's really clear for all parties. Now, because I come to law with a slightly different hat on, and to be fair to the law, gone are the days where big organisations can use their contracts as a stick with which to beat smaller organisations. The law works very hard these days to make sure that contracts have to be fair and they have to be reasonable and equitable for all parties involved. So I would definitely recommend you have contracts. It makes it very clear for everybody, and when you have a problem, it makes it much easier to sort out. So that's the first thing. Whether or not you've entered into contracts verbally and unwittingly is open to question. And unless I was party to your conversations, I would find that very difficult to answer. However, I would suggest that it's unlikely, because if you are offering your services by way of a quotation, for example, and then your customer is accepting your quotation by way of issuing you with an order of any kind, whether that's a, hey Richard, go ahead please, when do you start, or sending you an email to that effect, that would be you and your customer entering into a contract. And I would suggest that that's very unlikely to be unwittingly, given that you've issued a quote and they've then agreed and accepted your quote and asked you to go ahead.
Okay, thank you.
So that in itself would form your verbal contract.
Right.
Does that make sense?
It does, yeah, thank you.
Has that been useful?
Yes, very. Thank you.
Yes.
Yeah.
Excellent, thank you. I know it's a little bit legal jargony, and as Chris quite rightly pointed out at the outset, it's not a very sexy subject, but it is a really critical subject. It's really key, very important to businesses, and it always comes back to the point which Richard has very helpfully just raised, and that is, we should all have contracts in place. I've drafted contracts for painters, decorators, builders, right through up to multi-million-pound organisations, and vertical distribution agreements, which are subject to EU competition provisions. So there's, whether you're big or small, and this is the point I'm trying to illustrate, it's really key to have the right pieces of paper in place, and they can save you a whole world of pain moving forward.
Yeah, exactly. And on that note, watch this space, because Erika and I are putting together a legals bundle for agencies through Agency Local. So that's just a bit of a heads up, Richard, Paula. So that businesses that learn from this, that haven't got all those things in place, there's a way of getting them in a very cost-effective way and really protecting your business. So if there are no more questions, I'll draw that to close. Thank you very much, Erika. I've got, from that I took, we just need to start communicating. Oh, we've got a cat. Excellent.
We've got someone else joining.
So I would say, make sure that you communicate, customers and suppliers, find alternatives wherever possible, be reasonable and work your way through it, and just be pragmatic in everything that you do. And hopefully that will serve us all well.
Absolutely.
Thank you very much. Yeah, that was very good.
Erika, thank you very much. That was really useful. If anybody has any other questions afterwards, how can they get in touch with you, Erika?
So you can email me, if Chris, if you're happy to circulate my details, then please do email me and or call me. I'm very happy to have a chat and help people work through issues. Sometimes just a chat with somebody on the outside is a helpful way to solve problems.
Yeah, thank you, Erika.
Yeah. Indeed. Thank you, everybody. Stay safe.
Thanks for listening.
Cheers.
Keep safe, keep well. Bye-bye.
Bye-bye.
Bye.